Page 11, Millard.
11.
11. Starts from page 11.
Relevant portion is para 7.
Operating portion.
Para 7, may I read it?
Page 15.
Having
Millard.
appreciated the submission of the
Yes, deep thought. I will read it. Don't.
earlier order was also passed.
Yes.
Page 15, paragraph 9, 10, 11.
Billboards and all
Yes.
everything. Yes. What is the
Millard, my instruction is, Millard, all the billboards are installed, Millard. Along with that, complaint boxes are also.
can you file your affidavit?
Millard, I will file
Let
affidavit.
them file an
Yes.
affidavit disclosing. If you find that they are not telling the truth, definitely you can.
Not it. I have filed and today also I can show the snaps. Not yet. Even
They
if
are saying that they have put it.
certificate school,
Doesn't
nowhere.
understand. They are saying that they have put. You are saying that they have not put.
Uh.
So let them file an affidavit showing
Yes.
on oath.
Millard.
Yes.
With photograph they may show.
Yes, whatever they will,
Yes.
they will let them. The
No,
Does it
nothing.
lose its fragrance?
No.
It will remain.
Goodness.
By any other
Man,
means,
smells.
Yes.
Just because I was about to miss the case, that's the. My lord, the two minor errors have changed the fate of the case, Your Lordship.
What minor errors?
My lord, the petitioner joined the service on 15/5/2005, Your Lordship.
Yes.
And an amendment to the pension rules was made by an notification dated 17/9/2005. It has been held that I joined the service knowing that amendment, Your Lordship, which is yes,
That is the law.
he has given no objection.
What?
I will
That's the law.
I will ask
You
him to,
were not arguing counsel on the day when the writ petition was disposed of.
Right.
You'll have to justify.
I will ask him to be.
This cannot be done.
I will ask him to be present.
Are you aware of the Supreme Court judge case?
My lord, that I came to know everything.
He is carrying.
My lord, I got to know it very recently.
Adjourn. Take care.
Right.
Otherwise, we will not.
Item number 3.
Adjourn on the.
My lord.
What review?
My lord, my seniority in VC, my lord.
In BC
Yes, my lord.
is
I'm appearing for the review petitioners, my lord.
well,
In para 13 and 17, it has been observed in writ appeal that
where
we
is
do not belong
order?
to SC category.
Mr.
Sir,
Patel, where is the impugn order? Which page? Please point out.
Para 13, my lord. Page would be
Starts at 14. Starts at 14. So which page? Which paragraph?
para 13, page number is 16.
paragraph 13.
Paragraph 13, my lord. Last line.
Just
May I read, my lord?
so you do not belong to STSC.
Category. It was observed that we do not belong to ST or SC category, so they could
So
not
do you
claim.
belong? Do you
They-
belong to STSC or you do not belong to
We
STSC?
belong to SC category, my lord.
Now tell me from the writ petition, there is any document?
Yes, my lord. I'll try to
Where is the document from the writ petition?
satisfy my lord. Just
No, just
give me
point
2
out.
minutes time, my lord. My lord, after gazette notification, a panel was prepared. SC category was differently prepared.
First you point
We
out.
filed original application before the state tribunal after L. Chandra's constitution based
Sir,
judgment.
I understand. You are in a review jurisdiction. Kindly
Yes, my
visualize.
lord. I'll explain.
You have to point out the error apparent on the face of the record.
Correct, my lord. I have gone through the Maleswaris case recently in Supreme Court
Correct.
also.
So that is a problem with the virtual hearing.
My lord.
Patel, listen to what we are asking and then answer.
Yes.
Sir, you are under a review jurisdiction. Are you
Correct.
not?
Yes, my
You
lord.
have to point out that what is the error apparent on the face of the record.
Correct, my lord.
You have taken us to this paragraph
Yes.
where court held that your client do not belong to ST and SC category.
Correct.
which
my lord.
according to you is a error apparent on the face of the record. Actually, you belong to ST and SC category. If I
Yes.
correctly understood.
Yes, my lord.
Show us from the writ petition which document you have annexed, which shows that you belong to ST-SC.
Yes. For that, my lord.
That's
Uh,
the only
just
thing I
give me a minute.
Yes.
We filed original application before the state tribunal. It was decided on 20th December 2017. The first line, it has been stated the applicants belonging to SC category who have got diploma in civil engineering and had been empaneled by the committee under the chairmanship of chief engineer and so and so. This was challenged before the High Court in the writ petition. A batch of matters, more than 50 cases were decided by Honorable Justice Javeri and K.R. Mahapatra. The matter was remanded to the tribunal that to find out the exact vacancy so that these petitioners should be considered. By the time the state tribunal was abolished, so again it came as writ petition OAC with the same impugned order which was passed by the learned state tribunal. Thereafter, it was heard by a single judge. Single judge also decided the issue. Normally, if a batch of petitions are there, it goes to respective court or respective bench. So, according to the facts of the case, it is decided. Here, it was not decided. All writ petition was clubbed, and they say that this rule will be a new rule will be applicable. Then we came in writ appeal. So my respectful submission first is this was the impugned order in the writ petition before the Honorable Justice Chief Justice Javeri. Then again it was impugned order before the learned single judge who also decided the same issue. Actually, Anurag Sharma case was decided by Supreme Court, so our case was considered in that matter. Then we filed a writ appeal. In the writ appeal, this observation came. Had it been decided by the writ petition or before the tribunal, then this error would not have crept in.
Sir, I understand. I am again beseeching you to
Mm.
show me a particular portion of the document or a document that you belong to SC/ST. Please.
In the writ petition,
Yes, because that was a record available to the learned judge.
correct, my lord. My lord,
Please
then
show us.
then my lord, give me a physical hearing. Otherwise, document is with me.
No, sir, was it whether this document forms part of the record?
Yes, my lord.
Where is that? Show us. We are having a writ petition with us. We are having a writ appeal with us.
The OA again came with the writ petition.
Oh,
Original
show me from the OA that
para
where
6.4
annexed the document.
para 6.4 onwards. I have stated.
Sir, where is the document? If they are denying, then what happens? You
They are
may
not.
state a fact, but the other side in the opposition may have denied that it is not correct. Then it is the onus is on you to prove it that this fact is
No,
correct.
they have not denied, my lord. In OA, it is.
Show us.
If you lordship see the
when you offered your candidature, did you offer under a reserve category? Show us some documents.
para 6.4 in the original application before the state tribunal, in the impugned order.
What for?
My lord, this is the order of honorable tribunal.
I'm not concerned with the order.
Yes, my lord.
There may be a wrong observation in the order, and ultimately final order has come. if the final order does not indicate that you belong to SC/ST category, then in that event, this order goes merged with
No.
the final order of the higher authority.
My lord, in original application, para 6.4,
I am
page
saying, sir,
7.
how you have dealt with, sir.
Page 7.
You know the review jurisdiction. It
Yes,
must
my
be
lord.
apparent on the face of the record, means without going much deep into the matter, or
No,
what
you-
can be logically deduced after reading my various pleadings. This is not a purpose of the review. The court has said, no, you will not go into this.
that's what I
I'm
was
just asking
explaining.
a simple thing. One document, you must have a certificate that you belong to either ST or SC. Have you submitted that document along
Certificates I have
with
submitted with
or
the
a
review.
revision or a WA, anything?
Yes.
Sure. Matter
My lord,
is,
that
it's
is
a
why I'm
matter.
praying, my lord, kindly give me a physical hearing because the documents are with me. It is the annexures of OA. Original
Don't you have
application
a copy
before.
of OA with you?
No,
Yes,
sir.
No, sir.
I have got, my lord.
Your
Para 6.
counterpart is not having anything.
No, we
You
are
are
asking,
having everything.
asking Mr. Pal if he has. He's saying he doesn't have. So
Hmm.
he should have possessed so that he could have passed on or
You should
pointed
have
out.
asked the client or to me.
All right, all right.
Sir, when you are appearing virtually, at least your counterpart, Mr. Pal, is here. You ought
Yes.
to have given all the documents to Mr. Pal.
My lord,
So
I have
whenever
instructed
he asks the document, he will hand over.
I instructed the petitioner to hand over the OA, order, writ petition, everything.
So he is very reluctant. What can be done, sir?
Well, give me a physical hearing. I will come and
The part you are doing.
My lord, give me one more time, my lord. It
Yes,
is a
yes,
fine.
yes, yes.
Only one more time.
Sure.
He will present and
Do you also read so that you can assist him?
all file is
All right, all right.
yes, sir.
Why
I have no
then
file.
you
Only
are
review
engaged?
petition is there.
Sir, I'm really at loss
Yes, sir.
that when a junior counsel and a senior counsel are appearing,
Sir.
they are only having one set of papers.
Only review petition is there.
That's very interesting.
Sir.
Both
What-
of you must carry the full brief.
I have no file. Sir.
How you will read yourself? That means you are not reading the document. This is something very unique I could find. The senior is having the entire brief, the junior is left without brief.
I have left one copy at Katak also, so that they can
There.
go through it.
Same copy is there.
Only review petition is there.
Come on the next day at George. Whatever.
Item number 4.
Yes.
So this was coming and heading of admission, lordship. And
So what?
but this time it has come in orders, lordship, and they have filed a miscase. If will then press on miscase, lord, then I file objection. If
Sorry.
merit, then I can argue, lordship.
Sorry.
Lordship, interim application, lordship. Interim application, lordship.
That's all.
It was
Let's
earlier
change-
miscase,
let's
lordship. Now it is
change
amended,
this.
so we have the habit of saying miscase.
You have to change
It
the
will-
habit because so much time has elapsed since then.
Lordship, that is their mistake. From the day one.
Say nahi. Arey, I'm saying this referring to miscase and IA.
Lordship,
Yes, all right.
but we have that.
All right, all right. So why
Sometime-
why will he press for the IA when we can hear it?
Lordship,
I don't know.
They
You
have,
want to
they have
press for
filed
the
that
IA?
interim application. If they
ready for
they will, lordship,
Yes,
on interim
because
application, then I'll file the
midst of work, the work has stopped.
If
That
on
is why
merit
they have
basis, I
filed.
can argue, lord. So that is option to them, lordship. Justice.
No, on merit, let it on. Let it on merit. I don't have to. Because when
Yes.
Lordship. Lordship, in this case, the petitioner, how did with the work, lordship, since 5/11/2019, Lordship. And it ought to have been completed by 4/5/2021, Lordship. That is within 2 years, 24 calendar months, Lordship.
When he was awarded?
Lordship, 5/11/2019, Lordship.
19.
19.
Yes, then
Then it ought to have been completed, Lordship, by 4/5/2021.
5/11/2019.
21. Lordship.
And when is supposed to be completed?
Lordship, 5/11/2021, Lordship.
11 or 4/11?
That is, sorry, Lordship, 4/5, Lordship.
4/5
4/5/21.
4/5/21.
and 1.5 years.
Lordship, already.
4/5.
4/5, Lordship.
2021.
4/5, Lordship. Sorry, Lordship, 4/5.
Yes, then
But Lordship, due to there are the tender conditions fixed, Lordship. Just I want to read out, Lordship, two provisions of the terms of contract. Lordship, state I come to clause.
Fine.
yes.
Lordship, page, Lordship, running page, Lordship, can come to page 29. Clause 10, Lordship. Clause 9 says, Lordship, the contract is page 29, Lordship, the brief.
Huh. 29.
29 of the brief, Lordship, page 29.
Yes.
Lordship, clause 9, Lordship, I'll read for some time, Lordship, then I'll come to clause 10. Clause 9, only for Lordship. Work to be executed in accordance with specific drawing and orders. So, Lordship, the condition says the contract.
Where what to be executed in accordance with the specification? Always.
That is the Lordship.
So,
So, that's why the clause 10 speaks of Lordship. May I read Lordship clause 10? The engineer in charge shall have power to make any alteration on or addition to the original specifications, drawings, designs, and instructions that may be appear to him necessary and advisable during the progress of work, and the contractor shall bound to carry out the work in accordance with any instruction which may given to him in writing, signed by the engineer in charge. A such alteration shall not invalidate the contractor and the additional work which the contractor may be directed to do in the manner above precisional work. A part of the work shall be carried out to do in the contractor on the same condition in all respects on which he agreed to the main work. Then the next sentence is very important, Lordship. The time of completion of the work shall be extended in proportion. So they have, Lordship, right to alter the entire work.
provided the engineer in charge has altered and then extended, whatever.
Proportion work
In writing.
in
to be
writing.
signed.
Yes, Lordship. Then Lordship, kindly come to, just I am showing one document. Then Lordship, stated come to page 99, Annex 3.
Yes.
So it is on, Lordship, I had given 2 dates, Lordship. This work ought to have been completed by
4/5/2021. Yes,
21.
I have. And
Lordship,
this is a 16/3/2022.
22, Lordship. In 22, Lordship, this sequence of events, Lordship, kindly they are giving the approval of deviation of statement, Lordship. So in the 22, they come up with approval of the deviation of statement in respect of the work. Lordship, I'm just reading the contents. In inviting a reference to the letter number such and such on the subject cited above, I am direct to say that after careful consideration, government have been pleased to approve the interim deviation statement as per provision under para 6.317 of Open Code Volume 1, amounting rupees such and such, inclusive 12% GST, with next excess deviation of rupees such and such being 46.73% excess over corresponding agreement value of rupees such and such in the respect of the work in question, that is HL Bridge over river such and such, the name of the work, Lordship, awarded to Sri Viranchi Naran Singh, special
No,
contractor.
that is what is the approval granted by the government.
Lordship.
Where is the extension and deviation recommended by the engineer in charge?
Lordship, kindly state account to their counter. They have given in counter, that is in my internal page 123, but the counter dated, Lordship, counter held by Suraj Bishwal, he is the executive engineer. That is 23 April 2024, Lordship. That is para 7, Lordship.
Yes.
Yes, I'm reading the paragraph. That affirmation made in paragraph number 1 of the petition is a dispute denied. It is humbly submitted that on 2019, the chief engineer of Pan Road, Surat, government of Odisha, Bhubaneswar 2, invited a percent rate of tenders of the bridge work.
We are not concerned with that.
Let's skip to
Where petitioner was declared successful and executed the agreement on 5/11.
5/11.
So that is there.
Let's then
With a promise to complete by 4/5.
Yeah. Then next sentence. Write letter number 9069 dated 22/3/2021. The revised government approved drawings was approved by the chief engineer of building Bhubaneswar, which was committed to petition to execute work, and accordingly he was executed the filling wall bridge at work site. So Lordship, their own admission, Lordship, on 22/3/2021, just Lordship, the fag end of the Lordship, the work to be completed, only they provided the approved plan. So my humble submission, as per Lordship, the terms of contract, it has to be extended in proportion to that, Lordship, because they have done this latches, Lordship, they have never they handed over, neither they handed the site, nor Lordship, they gave the approved plan so that I can execute the work. So at a belated stage, just after the fag end of the Lordship, completion of the work, Lordship, they have gave this approval. So my humble submission before the authorities, Lordship, please grant me proportionate time so that I can complete the work. So Lordship, in the meantime, I had traveled this Honorable Court number of times, Lordship. And I had promised before this Honorable Court in 2023, Lordship, to complete the works within 4 months, Lordship. And Lordship, for example, Lordship, I have given all the
But that order was challenged before the Supreme Court.
No, Lordship.
4 months time.
No, Lordship, they made a statement about this court. No, we'll complete this within 4 months by giving contract to another contractor, Lordship. But they float this contractor, giving the time stipulation for 1 year. And this 1 year, Lordship, in the meantime, 3 years has been allowed, Lordship. Lordship, kindly please come to Lordship, only page 180. Lordship, kindly page 180, Lordship, 180, 81 and 82, 3 pages is important, Lordship.
But were you not granted extension till 31/3/2023?
No, I haven't granted, Lordship.
No, I will not. Were you granted extension till 31/3/2023?
Lordship.
Then why do you say that you were not granted extension?
Lordship.
134, 138.
No, I had granted name. You had been granted.
I had been granted.
Yes.
But that does not suffice. After that, I traveled this Honorable Court, Lordship, for 4 months to complete within 4 months, Lordship. Lordship, kindly come to page 180 for a moment, Lordship.
Yes.
Lordship, this is the photograph, still my materials. And Lordship, kindly page 181 is very important. Enter, I have done the structure, Lordship. The structure is page 181. The structure is there. That's why my undertaking was before the authorities. And also this Honorable Court has given a specific direction to them. If he is ready to complete the work within the stipulated time, within a short period, please allow him. But
where is that order?
Lordship, that order, Lordship.
Annexure?
Annexure, Lordship, I have quoted that order, Lordship.
No, where is it? Where is it?
Lordship. Lordship, kindly.
Yes.
Lordship, Lordship, page para 14, Lordship. Of the application, it page 8, para 14, Lordship.
Yes.
Lordship, can come to, I'm reading from para 4, Lordship, page 9. In course of hearing, Lord, counsel appearing for the petitioner states the petitioner has already made representation before the opposite party number 5 and Annex 6, and the same may be directed to dispose within a stipulated time, to which learned counsel for the state has no objection. As agreed by the learned counsel for the parties, and after going through the records, this court, without expressing any opinion on the merits of the case, disposes the writ petition directly upon the 5 to consider dispose recommendation of file petition of 6 by pass after order in early month period of 3 months from the date of production of the certificate. This recommendation was to complete the work within 6 months. No, that is it.
Court directed,
extended. Next, I'm going to next order also. I'm going to next order also. This depends are rejected. Then again, I approve this honorable court. Then let's you kindly come to
Which one?
which order?
let's you kindly come to page 13.
Yes.
Page 13.
Lordship, order dated 15/5 and 24. Lordship.
Yes.
Mr. S.K. Dalai, learned counsel for the petitioner, undertakes to file an affidavit by Monday, indicating therein the time period by which the petitioner can complete work by serving a copy thereof.
So what happened? Affidavit filed?
Yes, Lordship. Next order dated 26 and 24.
Yes.
In compliance with the order dated 15/5/24, the affidavit is filed by the petitioner on 18/6 and 24. Whereas paragraph 3 and 4 states as follows: the petitioner was ready and willing to complete.
Anyhow, no order was passed. They were supposed to take instruction. Then what happened?
With June, they
Yeah.
didn't. Let's
Yeah.
let me not read that.
So nothing.
Yes.
You said you will do it, but they say they want to take instruction.
That's
Then
it.
after what
They,
happened?
they did not do it, Lordship. They did not consider my recommendation. That's why that is my grievance before Lordship. Had it been Lordship disposed of, or had it been at the same time, the matter would have been Lordship resolved. Then today, Lordship, the situation.
Well,
Lordship,
the representation was issued.
Wait,
That's right. Don't hijack the right to argue.
then Lordship kindly come to Lordship. Then Lordship, by virtue of this order, Lordship, they rejected my application. And Lordship, again I am challenging the order of the Lordship cancellation. I approve this honorable court, Lordship. One second.
this writ petition.
This no, Lordship, another writ petition, Lordship.
Another writ petition.
Yes, the two writ petitions pending.
Oh, yes, yes.
Lordship, can you remember this writ application?
I remember very clearly.
Lordship, that was my grievance are during Lordship when the judgment was reserved. Without Lordship, they did not intimate to court that there is the judgment. When the judgment was reserved, Lordship, without taking confidence this honorable court or intimating that the case is pending, Lordship, they declare the result and Lordship award the contract to the present opposite parties, Lordship. That's why, Lordship, in this writ application, your Lordship interfered with this writ application with such interim order.
Huh?
Lordship, interim order, that is Lordship on 27/1 for 25, Lordship, kindly.
What entry order?
Lordship, kindly, I'm reading, Lordship.
What is the entry order?
Lordship, I'm just reading the order, Lordship. Yes, Lordship, 27/1 for 25.
Yes.
Mr. Dalai Learned advocates appear on behalf of the petitioner and submit that his client had challenged order work order dated such and such, and during pendency of his client's writ petition, subject matter of which was the tender, he refers to extracts of the quotations of several orders made by court magistrates, ending with order dated 20th August 24. He demonstrates there was a record of hearing concluded and the writ petition reserved for judgment. Mr. Tripathi, learned advocate, additional government appears on behalf of the state. He submits there was no interim order of restraint. That does not answer.
Shall remain state.
Lordship.
So the 6-member work order shall remain state.
On further query, we are told that
You don't have to, sir. The form is here.
Lordship.
So there was an interim order that why the work order dated 6-member will remain state.
Lordship.
27/1.
27/1, Lordship.
Was it extended
Yes, time to time.
till the judgment is reserved?
No, judgment is there. That is now released, Lordship. That is now subject matter of Lordship. Both the writ applications now here, Lordship. So, Lordship, my humble submission is Lordship. Lordship, kindly.
Work order has been stayed.
Yes,
Yes,
that work order has been stayed.
yes.
So, Lordship, just I was happy, Lordship, to see their miscase today. Lordship,
What
their
is case?
interim application. Sorry, again, their interim application. Now they are also, Lordship, They have also now selling in same boat, Lordship. They also realizing what was happening with me. Lordship, can is there interim application? Lord, now it is happening with them. Lordship, because Lordship, the state is not resolving the issue because of the Lordship, without any Lordship coming with a solution, Lordship. Lordship, kindly remember, Lordship for us party to that. At the same time, the state government had rescinded 121 numbers of works, Lordship. We are at the time before a Lordship, and we Lordship convinced this honorable court that Lordship, yes, Lordship, we have convinced the honorable court, Lordship, not convinced the honorable court, Lordship, because by your Lordship, perhaps the Lordships are there because in tender by 121 matters,
No.
almost all matters, Lordship, we are appearing, and because the state Lordship committed a mistake at the overnight, Lordship, perhaps in all the matters, Lordship. Perhaps state Lordship committed one night took a decision to rescind 124 numbers of works. So Lordship, the financial implication of their Lordship, we demonstrated to the honorable court, state is going to suffer, Lordship, and to lose more than 1,000 crores of revenue. That's why Lordship court take a very lenient view and directed them, and all the rescission proposals has withdrawn by the state government, and proper time was granted to all the contractors, and all 24 numbers was perhaps in the meantime has already been completed.
By not awarding the contract, the court, the government has saved 1,000 crores.
Lordship, if had it been
Has saved
1,000, more than 1,000, saved. Had it been, Lordship,
This is good for the government.
yes, Lordship. That is
saved the money.
That is only for our effort, Lord, not for them, Lordship. Here the case, Lordship, from the day of governmenting, I am not against this opposite party, Lordship. If you complete work, I don't have any objection. But my humble submission was, Lordship, before Lordship, if I have completed the work, let it be closed. Lordship, you close the entire work, Lordship. You give me, because only my humble submission, because why I am challenging this order, Lordship, there is a Lordship penalty clause.
There is a
Penalty clause, Lordship. Penalty clause, Lordship, there.
So they may
If
a penalty clause.
Lordship, definitely, Lordship.
If they give you an immunity, you are happy.
I'm not saying immunity, Lordship. Because Lordship,
no penalty should be imposed.
No, I'm not on that, Lordship.
Then you say the penalty clause is there. You are, Mr. Dulwari, there are two submissions which we have. One is that you say that you have no objection if he completes the work.
Lordship.
There's no difficulty.
No.
Now that shows that you are not interested in now continuing with the work or completing the work.
Lordship.
Second thing is you are apprehending that since you have not completed the work, they may invoke that penalty clause.
Lordship.
And you will be saddled with the penalty.
Grateful.
If this immunity is given to you, I think everything is sorted out.
That day when I'm saying, because that's
the immunity means you are no penalty to be imposed.
Because Lordship, at the same time, Lordship, to consider, because of their laches, I should not suffer. That's why I'm showing the clause, Lordship. Had it been a case, the clause 10.
Then what you want?
Lordship, my humble submission before Lordship. Lordship, kindly see, they have committed two mistakes, Lordship.
What you want now, the relief, Mr. Dulwari?
Relief, Lordship, my humble submission before Lordship. Let it be, Lordship.
Oh, that is what
let it the work may measure the Lordship. Kindly see, I show demonstrate my metal spending.
Say that whatever work you have done, be measured.
Lordship.
And the payment according to that be made to you.
Lordship.
That is
Lordship, that day one I'm saying, Lordship. Day one I'm saying, because they have entered into another contract. That is my enter given to Lordship.
Have they paid the money or they have
not
paid the money for the work?
No, they have not paid.
No. Okay. What is the stand of the state? Now this is the
State.
what is stand? Why don't you resolve it? You content think this is relating to what? The fiber or a bridge or what?
Bridge.
It is a bridge, Miller.
Over the river.
River.
It's complete.
No, it's not complete.
Now you wanted a completion.
Yes, Miller.
Why don't you take a sit and then decide it?
That's the kind of may.
What he is saying is that whatever the work here, it is as per the script. Give them the money. You are continuing, you have awarded the contract, let them continue and finish it.
Miller, now the fact remains.
You will vacate all the instruments.
Let's may take you to the some dates.
It's an amicable solution. We are not merit. We are just proposing that this called the bridge is for a larger public interest.
Yes.
It's an easier commutation. Is it not?
Yes.
So we cannot expect that the bridge will remain in such unfinished condition for years together. It's temporary. It has a self-life. Why don't you take a conscious decision? Complete the work. If you think he has come, you wanted to do it, finish.
But let one thing to be brought to your notice.
No. If you want to argue, then I will hear
No.
and then we'll decide.
Not
We are in the midst. We wanted to reconcile
Yes.
or a conciliation proceeding to be initiated to resolve. He does not want to continue. Now he has got up.
and the contract is resigned also.
Oh, whatever, rescinded, not rescinded, it's another. Okay. What do you want?
He had also prayed in the writ petition for granting time. Now he is giving that up. So on basis of that,
If the interim order will
Court, please take a conscious decision. We said that we will vacate the interim order. We'll vacate it immediately.
now he is only bothered about the penalty.
Only thing is that do not impose penalty. Whatever he has done, if it is in accordance, pay off and then let him complete the work. He does not want to complete the work. This is what an amicable solution you can brought. You have to pay the money.
Let's take up this matter.
Do I call the Advocate General to intervene in the matter? So these are the matters pending for such a long time. It's hampering the entire very useful and utility
Yes.
purposes, the facilities.
Let's fix up this matter to the next week at the top of the list.
Is he there in the court?
Okay.
Is the Advocate
Mr.
General
Said,
there?
London AG?
He's not here.
Not in the court.
In the town or in the court or?
Not in the court.
Don't know why. No, we are granting you adjournment, but we wanted this adjournment should be purposeful.
I will communicate it to the candidate.
You communicate, they will say no. That's not a solution.
That will not bring an end to this matter. Some aggrieved party will be there, something will be there.
To the matter. In a more honorable way, so that everybody may not have any kind of a.
Grievance.
Yes, what are you looking at? Is he supposed to be there on virtual mode in this matter?
Probably
He's not.
sometimes not all.
My lord,
My lord,
my humble submission is that
Who are you, sir?
I am the substitute contractor who is taking over the
Sir,
work.
we are saying that you continue.
Yes, ma'am.
We are saying that you may continue. That's what we wanted.
Let us continue. And the quarrel between the state
Can keep this matter. Tell us.
The next sitting.
No, not next sitting. It should be a short date
Short.
because unnecessarily everybody is
You will
waiting.
not keep this
Monday. If possible. On Monday. On Monday.
Monday will
This
be
Monday?
possible for you. That is too
You
short.
will be able to do it
Letter will go yours from your office. Take
Saturday
2
is
days
working.
for letters to go.
next Friday. Keep it.
Right.
20th.
Yes, my lord, my humble submission is that when
20.
I will let me allowed to first due to the result of this case because I may be allowed to continue my work because which has been stayed
Sir,
subject to result.
Sir, I tell you very frank. An interim order was passed.
Yes.
You have asked for a vacation.
Mm.
There are two modes of vacation. One is under Order 39 Rule 4. Then you'll have to say what is a gross suppression of the fact and all these things. And second is, if you are not given an opportunity, then you'll have to show that why you will not get an order. So you cannot do it in this way. So we have to record the reasons for vacating the interim order.
Yes, that will be it.
And this is operative not now, it's operative
Since
since 2023.
when the stay order was
my humble speech, when the stay order was passed, by that time I was not a party. When the stay order passed, no notice had been issued to me.
Now, that's what saying that whatever is there, let them find out 1 week time. Let them come on the next Friday. We are keeping this matter on next Friday, 20th. No problem. Yes.
Item number 5.
Next.
Both. Oh, both. Where is the order dated 13/8/24?
27, my lord, at page 27.
27.
There is patent error on the face of
Earlier matter. After getting the rest. Yes.
my lord, there is patent error in the order dated 13/8/2024. Honorable single judge has quoted the order, my lord, in which, my lord, it is completely error on the face of record. In WPC number 11748 of 2003, this honorable court has not directed, can say quashed the selection, my lord. Only direction was given 15,682 posts, which are filled up on the basis.
No, this is the writ appeal.
Writ appeal, my lord.
Writ appeal.
Here, my lord,
The appellate court
is committed.
simply recorded what transpired from paragraph 41 and 42 of the impugned order.
41, my lord, paragraph 41, a batch of cases it has been filed. In paragraph 41 has already been reviewed by the honorable single judge and allowed the repetition or other batch of
No, I do not know. Is it a correct reflection of paragraph 41 and 42?
41.
Oh,
Asking what is quoted, those paragraphs are correct or the quote?
That is not correct, my lord. Therefore,
show us the judgment which the division bench has
yes,
quoted.
yes, my lord, you lost
That
it.
Mr. Mahanti, we are not asking whether it has been I mean, the contents are correct or not, whether it has been quoted correctly.
Quoted correctly, but the contents are not correct, my lord.
Means what?
My lord, my
If
lord,
it is
means,
correctly
my
quoted,
lord,
then why contents are not correct?
my lord, I'm placing only your lordship. Your lordship, para 41.
Para 41.
When the recruitment process is declared null and void, in WPC number 11748 of 2023, the petition ceased to be an employee of Shiksha Sahib, but this portion of the order, which is not actually the order in the past in 11748, and therefore the honorable single judge has already reviewed his honorable.
So then where is the error?
Error,
If a single bench has committed a wrong, please.
Yes,
the division bench has simply quoted what the
yes,
single bench has observed. Where is the error of the
error, my lord?
The appellate court. Where is the error committed by the appellate court?
Appellate court error is there, my lord.
Show
At paragraph 9.
Please.
After having perused the pleadings on record and considered the rival submissions made on behalf of the parties, it can be easily inferred that the appellant's initial selection was against a post which was not advertised. That is not correct, my lord.
Where is the record?
That record is, my lord. You lost.
Where is the record?
Record. Your losses can come to the Writ petitions that advertisement was made on 25/3/2003 for 419 posts. 419 posts. 419 posts in for Rairangpur Education District.
out of which 46 posts are reserved for the ST male.
The observation is that the appellant's initial selection was in respect of a post for which there was no advertisement.
There is an advertisement on 25/3/2003.
I do not know that the initial selection, it talks about
Made.
the initial selection when you were selected.
I was selected for in respect of 46 posts.
I am asking you, sir,
Yes.
when you were selected. When? I have asked when.
My lord, I was selected in the month of May 2003.
Three. May.
I was
And when
given
the advertisement was,
on 25/3/2003.
was there any the application made by you?
Yes, my lord, application was made.
Was there any written examination or an interview
No, it was
or
on the
whatever?
on the basis mark basis, mark basis in matriculation.
Yeah.
I was selected as a ST male candidate.
What is this post? This post was in a particular place.
Yes, Raipur Education District.
Correct. Was this particular post advertised?
Yes, my lord. Your lordship, I come to Annex 1 to the restriction.
This is the.
My lord, Justice RATHO can see, my lord, because in Odia.
Read it in Odia. Everybody can understand.
My lord,
Both of us.
Annex 1, Raipur 419 posts. Your lordship, on the middle of advertisement at page 15 of Writ petition.
Writ petition. Wait,
Yes.
wait, please. Writ appeal.
Writ petition, my.
No, that posting is a different. Sorry, this was taken into consideration in paragraph 4.
Paragraph 4 of Writ petition.
No, there's impugned order.
Impugned order.
Yes.
Yes, my lord.
Advertisement
Then
for
I have.
119.
You are an applicant against that.
The submission was that it is not in dispute that he was later on engaged, but not in 419 posts, but against 15,652 posts, which were never advertised.
My lord, I was not selected against 15,682 posts. I was selected against that.
So it may be,
posts.
it cannot be said. This is a positive finding of the court. It may be an erroneous finding, but it cannot be termed as an error apparent of the
Fact error of record, my lord. You lost it. Therefore,
Mr. Mahanti, it's clarified that you were one of the applicants for that earlier thing. Subsequently, when you were appointed with those 15,681,
no, I was.
That time there was no.
I was not appointed.
You were not engaged.
No,
that is a
I was engaged. I have. My you lost it kind.
You go higher up and challenge.
No, my you lost it kind. See, my lord, this honorable court has honorable single judge has already reviewed the matter. In batch of cases, my this was order passed. Your lordship kind of it. Lots of it. In all cases, it has already been. Lordship kind come to paragraph 24. Conclusion of the review. This court is thus satisfied that the common judgment dated 22/12/2023, where the present petitioner suffers from an error apparent on the face of record, that it proceeded on an unstated but crucial assumption about the court or post to which the petitioner belongs, without advocate rival case borne out by the materials, and the consequently applied the non-prejudicial or ritual hearing doctrine to be case where
Then what to do?
my lord, recall.
What to do?
My lord, because this is the order of honor division bench is there, my lord. Therefore, I have sought the review in respect of my case.
In Vanita Behra, the appeal was preferred.
No appeal was taken. No. On the presumption, my lord, that selection was quashed in WPC number 11,600,
Dismissing
WPC 748 of 2003 Rustikation Mindhani case, that entire appointment was quashed, my lord. But that in the judgment, my lord, that judgment was in respect of 15,680 posts, not against the 490 posts which is advertised on 25/3/2003, my lord. On that wrong presumption, but the appointment was quashed, my lord. Repetition was dismissed. Therefore, I filed the review, my lord. The later common judgment has been quashed, my lord. Your lordship, I have
Qua that petitioner.
reviewed, my lord. Enter common.
Qua
Record.
that petitioner, not the entire judgment is recorded.
Yes, my lord. Therefore, I have sought for the.
And if it is recorded,
Yes.
then there is a nullity. If a judgment of a single bench is affirmed on merit by the appellate court, then the single bench cannot
No, in
review its
respect
judgment.
in respect
It's
of
a nullity.
In respect of
It's a merger of a single bench order into a division bench order. Cannot
it is
review its
personal
own order.
It is personal concern.
So it is only
Personal.
because that's why I asked whether this petitioner preferred an appeal or not.
No appeal.
So that's why the single bench has said co-op petitioner, not own.
Isn't petitioner alone? Regression observation will not operate against her. There's some difference between the categories. There's a petitioner engagement was against one of the 16 scheduled caste women posts notified under section 25, under 25/3/2020.
Here for 46 ST male candidate in the present case.
So challenging that common judgment, no other writ applications or review petitions were filed. Only one writ appeal and one review petition
All the case, review has been
allowed.
all the cases.
All the cases review has been allowed. Can't be all, because one had preferred writ appeal.
Only one.
Only one.
Only
That only
writ
state
appeal.
can say.
Here, my lord,
How many cases had been decided together? Common judgment?
13 or 14 cases.
13 or 14 in the writ petitions.
14 to 16 cases. All the 15 have been read.
Was it brought to the notice of the learned single judge that this writ appeal has been dismissed?
This is in respect of estimate candidate.
That is there in the judgment.
No, that is not. It was not by the state council. It is there or it belongs to other part of it. SC male, SC female, and SC female. Estimate is the only sole estimate candidate. Out of 36 posts advertising in the 25 days 2014, the first page they have given those who are matrix 60 candidates. 12 candidates are available first they get appointment. Then, my lord, the collector wrote to the government that we have already given that
There remains a certain post vacant.
living certain. Against that post untrained, I was the untrained candidate at that. I was given appointment because in the advertisement there is condition that the tribal untrained candidates can be given appointment by the. I was given appointment. Then I was sponsored to undergo the city training. I completed.
I have done.
Then, my lord, what they say that the 15,680 posts.
Why you did not convince the earlier division bench to dispose of the matter?
My lord, the earlier division bench, my lord, I was not the council.
Can you argue now, reopening the entire thing?
I had not because
What was told to the council in the other cases?
Please give him a judgment. Give him a judgment. First paragraph or a second paragraph of the Supreme Court judgment. Second paragraph of the Supreme Court judgment. Or first paragraph, I believe so. Supreme Court has deprecated that a counsel who did never argue the matter before the original bench shall not be permitted to argue in the review. Go through it. What can be done? And Supreme Court imposed in 1997 20,000 rupees cost. We are in 2025. 28 years have, or 2026. 29 years have passed.
I will give the
20,000 will go, how much multiplication? How much?
I will give consent to the consent.
I do not know.
I will give the consent.
Yes,
I will give the consent to the
whatever,
poor petitioner.
whatever, take it.
Yes, please.
Is adjourned next week. Yes,
Item number 6.
hey. Oh, we have to write this. Sir, what is,
We are helpless, my lord.
Where
just
is he?
called him.
Very good.
Already informed, my lord.
So what he's doing? Why he's not coming? I will request him to come.
My lord, he is a little bit out of station. He asked somebody else to come, but I
This
think
is not correct because the documents are.
This is a case, my lord. The petitioner was discharged from the services and reference was made. Their award has been passed. Award, my lord,
First,
the-
tell us what is the order you sought to
the
review?
impugned order, my lord, page 20, 10/1/2025.
Just give us 30 seconds time to go through it. Just wait. Yes, sir.
My lord, the paragraph 8 and paragraph 10.
Yes.
And this is the section 11A. that came into force in 1971. 71 aims and objective of the act, and that is the consistent view of the Supreme Court so far in the interpretation of section 11A. On proved misconduct, court can exercise discretion to the effect whether it is disproportionate or shockingly disproportionate. Doctrine of proportionality that may be considered, and reduce the penalty in the event it is found. Page 25, paragraph 8. This is the Lacombe's judgment that has been referred. That is also the view of the Supreme Court, and that has
but the court has taken into consideration.
Court has taken. You'll also kind of see last 3 lines
and apply and say that in what circumstances it will apply and in what circumstances it will not apply. So if a court has taken a conscious decision, if there is any finding which according to you is not that appropriate, then it is an erroneous order.
Court has found,
now you can't re-argue the matter.
No, I am not. I'm not on that.
You are re-arguing the matter.
No, I am not. I am not on that matter. This statement.
Not on that. There is an error apparent on the face of the record. Para 7 also. When you are reading para 8, must be para 7. Everything has been taken into consideration. The court must have perceived certain judgment to have been laid down this proposition of law. May not be so, but that does not mean it is an error apparent on the face of the court has interpreted.
Court has simply said, since it is not proved.
What is it?
That is, the court has said when it is not proved.
No, it is really an erroneous judgment. You go higher up. But you can't argue in this way. A review is not for re-hearing, re-arguing the matter.
The Supreme Court judgment that I want to bring about.
Tungabhadra of 1968 Supreme Court till this time was consistent review jurisdiction. Rupa Ashok Hura of the Constitution.
Fine chemicals also, that also says.
No, sir. This can't. And my own judgment is staring at my face.
Will you not permit to submit these submissions?
No, you
take cognizance of this, and you'll also know. You'll also take cognizance of the submissions and pass on this.
Misreading and misconstruction. So this will not come under the review. Have you examined your citing a judgment of the Supreme Court in CST versus fine chemicals?
Yes, ma'am.
Have you read paragraph 10, last line?
Paragraph 10.
Last sentence.
Yes.
What is that? Why Supreme Court is under Article 142?
Yes. Yes.
Not under review.
Yes.
So, last 2 lines.
Yes, that is.
The 2 decisions did not certainly support the interpretation adopted in the judgment under review. On the contrary, they are in particular the decision in aluminum mitigating against interpretation, then the court has said it is for this reason, coupled with the fact that the interpretation placed in the judgment may affect a large number of cases all over the country.
That's absolutely.
Then we decided to examine the issue, which we would not have done it ordinarily.
Absolutely.
That shows Article 142.
Absolutely.
So how this lies? No, sir. Very difficult. Right? You would know. Because my brother is a party to a judgment, so he should write the review order.
I am appearing for the opposite party.
Thank you for your appearance. Concluded, give it to us.
Item number 2.
No, by judgment, which is acceptable.
So if I may please your lordships, my lord. My lord, Annexure 1 is the order which is sought to be complied. Annexure 1, your lordship.
17.3.
My lord.
Just give us 30 seconds.
My
Oh, is that content? Sorry.
Content.
What is the operative portion?
My lord, page 11.
Oh, what is the direction?
My lord, the directions are that which were passed in the judgment of Rakshagopal Kalo. My lord, that Rakshagopal Kalo, my lord, is Annexure 6.
That is the judgment dated 17th February.
Yes.
Where is that judgment?
My lord, Annexure 6.
Annexure
6.
6.
Filed by way of an affidavit, your lordships.
Page.
Affidavit, my lords, page 4.
Let's see.
Relevant page 17, directions.
Relevant page?
17.
So your name was restored to a provisional merit list.
Yes.
For onward action on the appointment to be made pursuant to the recruitment of 2023.
Correct, your lordship.
So they have not restored you.
Till date, not done. Then they preferred an SLP before the Honorable Apex Court.
Then what happened?
The SLP has in the meantime been dismissed, my lord.
Huh?
The SLP has been dismissed, Annexure 8, page 24 of the same affidavit.
On 6th February 2026.
Yes, so it has been it is dismissed.
Dismissed. And the Carlos judgment also, my lord, by the Honorable Apex Court, it has been dismissed. Excuse me.
Yeah. Then
Now it has been Carlo, my lord, was pending. Then now it has been dismissed.
no.
Yes.
What is then what it means, sir?
We'll file a reply.
Reply.
Milord, because I have taken instruction, Milord, after dismissal of this SLP on 6th February 2026, Milord. Now the process has already been started, Milord.
No, first thing is that you have to restore his name in the provisional merit list. And then all consequential actions have to be taken thereupon. So what is your stand with this?
Milord, after dismissal of the SLP, Milord, now they have started the process, Milord. Only that much instruction I have collected.
What?
Process has already started, Milord, to restore.
Have you restored his name?
Not yet.
No. It's a 1 minute exercise to restore. And consequential steps I can understand for appointment will take time. But restoration has to be done immediately. So, the effective has not granted contact time.
They have not granted. Let's see, call this matter next week, Milord. In the meantime,
Fit case for a rule.
let I understand.
You are issuing a rule. Let him appear.
Let's see, call this matter next week, Milord. For the first time, it is coming.
It is offered. And there was no stay granted in the SLC.
Yes, Milord. I am conscious about.
What is your stand? Despite the
My lord. Item 11 also same thing. That is the.
Are you in a hurry?
No.
Yes.
Item 3, Milord. Before I make my submissions, but I have something to say, Milord. This the writ petition, the order of which is under review now. Sorry, matrimonial appeal. Was initially filed by my learned friend Mr. Pradhan. He had argued the matter. Then, while filing the review, Mr. Patnaik had filed. So, because of the Supreme Court decision, the Honorable Court took note of it and passed an order on 7/11/25. 7/11/25, order number 2, saying that because of the Supreme Court decision, the same counsel has to appear. But thereafter, why I make this submission, I beg your lordship's indulgence. I don't know, because now Mr. Pradhan is also appearing in this case.
No difficulty.
No difficulty. But he has engaged me. If your lordship permits me only, I can note that, because he has engaged me. Or if it is strictly construed, the counsel will appear, then Mr. Pradhan will.
No, he can assist you. No difficulty.
He can assist me. He is there to assist me.
We are not that technical, except that he should be there.
No, he is there.
Stand by what he argues.
No, he is there. He is also signed the wakalatnama, filed his power, everything is there. Only thing, he has engaged me with your lordship permission.
Yes.
My lord,
What is a
my lord, before my learned senior begin, may I request your lordship may grant me short adjournment, because my learned senior is on his legs today. If I may, my learned senior is on his legs today. So if I may request for a short adjournment.
no adjournment on the ground of the seniors being engaged in another court.
My lord, any day, my lord.
Order 17, Rule 2 of the Code of Procedure, please read.
My-
Read that. No adjournment shall be granted.
my lord.
Page. Code of Procedure.
There was a case long back, 30, 40 years back,
Read
which
that.
went to Supreme Court.
Order
Also.
17.
Adjournment.
My lord.
Order 17. Lawyers.
My lord. Procedure, if parties fail to appear on
No.
No.
You see, back at the pleader of the file
Leader.
is engaged in
Another court.
And
the heading cost of adjournment.
my lord.
Who is cost of adjournment? Just go through C.
Order 17.
It is.
2002 amendment.
Yes, my lord. I was carrying the old one, my lord. I'm sorry. My lord.
Sir,
The
the
fact-
language
yes.
is that the fact that the pleader of a party is engaged in another court
My
shall
lord.
not be a ground for adjournment.
My lord.
You are asking, cannot be adjourned. I'm giving you a provision of law.
My lord.
So,
I got it.
shall what is used,
My-
mandatory in nature.
Any date, my lord, just to assist your lordship.
Then let us first see whether it requires any
Madam.
interference in the review jurisdiction. It
Madam.
may not,
As your lordship, please.
it may.
As your
Yes.
lordship, please.
This arises also matrimonial case. Where?
Is a degree for divorce
Yes.
under Hindu Marriage Act, section 30,
That is the question.
on the ground of cruelty or on the ground of desertion.
Just
What?
before that, the husband's application for divorce.
For dissolution of marriage. See,
Dissolution of marriage.
exact language.
Exact language. So that was rejected once.
By the trial court.
By the trial
What
court.
was the ground?
Ground is that the parties belong to scheduled tribe, and so therefore Hindu Marriage Act provisions will not apply.
Correct. I think section 2 or
Two
3 of the
of the. that was closed. That chapter was closed.
Correct.
Then he again filed another petition under the old Hindu law 441, saying that they are governed by the old Hindu law and they are tribals. So therefore, sought for divorce. The learned trial court or the family judge, learned family judge said that again reverted back to that since the parties are tribals, this will not apply. Again, this reiterated that your lordship is just, I will just go through that.
Just give me Hindu marriage.
From the impugned
Hindu marriage act.
2.2 has been quoted also.
It is.
It
is.
Lord, here, just before I start the case, Lord, I just like to invite your lordship's attention to paragraph 7 of the judgment under review. The bench which passed the order which is under review. Paragraph 7, your lordship.
Is it this caste which they belong is notified under
Yes, that is exactly what. But those things, yes.
Scheduled caste or scheduled tribe?
Scheduled tribe.
Then Article 342.
Yes.
Presidential notification.
Yes, those things have been admitted. I'm just pointing out so that your lordship will be clear. Paragraph 7.
If it is not, then if it is a Hindu Marriage Act is not applicable, then what?
Then the marriage can be dissolved according to the civil tribe custom. There is no quarrel over that proposition. The division bench has held that no. I think if I place it, your lordship will be clear. I think that part will be clear.
No. I'm just thinking it's an interesting point. Yes. That's why I'm ignoring that concept of review for the timing. I'm ignoring the concept of review for the timing. Just try to understand.
Lord, what I'm saying, the first round of litigation ended.
Oh, that's the clear finding that they belong to a scheduled tribe by virtue of this section 2 of the Hindu Marriage Act. They are outside the purview of the Hindu Marriage Act.
The trial court dismissed his divorce petition, the dissolution because only on the ground.
Second time he filed the what provision?
Order 441 of the old Mullah Hindu law.
What is there is no codification of the
No
law.
codification.
There is
But
no-
he has,
That's a commentary.
but he has nomenclatured it under 441.
What is this? It's not a Muslim law.
No, no, no.
No, no.
Eight. Mullah.
That's not a law.
Correct.
No.
That those are commentaries. Anyway, but
441. The restitution.
444 one, sorry.
444 is not there.
But he has 444. The 441.
No, adoption. No.
441. My learned friend says that he has filed it under 444.
It's a case of object of adoption.
No, my lord. May I just hand over?
That it is, I think.
My lord, may I just hand over the?
That's the restitution.
That is confusing.
Not restitution.
Not.
May I just hand over that 441? I have taken the control.
That's an old edition.
Old edition.
I think the edition.
That's why the paragraph.
These are the commentaries. It becomes a law. Then you have filed before whom?
Family
court.
Can it lie?
My lord,
First thing is, can it lie?
My
Then you
humble-
have to approach the civil court.
my humble
Family
submission is
courts are exercising the powers only in respect of a law relating to a matrimonial.
Well.
If it is not coming either of this, neither under the Special Marriage Act nor under the Hindu Marriage Act or whatever, then will it not like a civil suit?
My lord, may I just make a submission, my lord? My lord, this argument was raised before the Honorable Division Bench, and your lordship may kindly see Section 7 of the Family Court Act. Section 7 of the Family Court Act, my lord.
Where is that? Family Courts Act. That's it. No, it is not.
No, wait, it is. B. Explanation
lord,
B.
That is subject to the other provisions of this act, a family court shall have and exercise all the jurisdiction exercisable by any district court or any subordinate civil court under any law for the time being in force in respect of suits and proceedings of the nature referred to in the explanation.
Where is the explanation?
Explanation.
My lord,
B.
suit or proceeding referred to in this subsection are,
Definition of a first thing is a nullity,
my lord,
then restitution, judicial separation, resolution.
my lord.
Yes.
Therefore, my lord,
The first sentence was given, which may not have exercised all jurisdiction exercisable by any district court or subordinate civil court under any law for the time being in force. Any law for the time being in force. So now his case is that he is not governed by Hindu law. He is governed by the
customs and uses.
So therefore, marriage, Hindu law, loosely Hindu marriage act. So these words under any law for the timing in force. So those things, the jurisdiction of.
Did you raise this objection in the instant?
Yes, ma'am.
Instant.
In your judgment, did you raise?
Yes, Lord. That is what I wanted.
Has it been dealt with?
Paragraph 8 and 9, my lord.
7, I'll place it from 7. Your Lordship, place it for 7.
Yes.
The
Has it
paragraph.
been dealt with?
Yes, on perusal of the impugned judgment,
what the court has
said that the parties cannot be left remedialess,
correct.
and therefore,
So that is the decision.
yes.
Now coming to a main. Does it come under the purview of the reviews? If a court has taken a particular decision, a finding may be Justified.
Your Lordship says it's
justified.
a wrong judgment.
Erroneous or a wrong judgment.
Wrong.
Go higher. Can you go for a review?
My only grievance is that Your Lordship sees that their tribals admitted
Maybe
that the adjudication
so it's an erroneous judgment.
erroneous.
Not an error apparent on the face of the record.
Error apparent on the face of the record is this.
From the record, it should be apparent.
Yes, from the record. I will show it from the paragraph 10, Your Lordship sees.
Nothing.
Paragraph 10.
Yes.
This brings us to the petition filed by the appellant husband. By it was invoked 441 in Mullah's principle of Hindu law, subsequently corrected as Article 441. There is no dispute before us on the parties following the Hindu way of life.
So what?
That is an error. That is an error.
What is the error?
That they have not.
Is there anything from record says that they are not following the Hindu way of life?
That is never the case. That is never the case.
That's an observation. If it comes from any of the findings or the pleadings or the evidence, then
after holding that, what the Honorable Court proceeds to decide on merit, which was not decided in the trial. Merit and grants the
that's erroneous. No. Maybe. It's erroneous.
Your Lordship is
The court has the only judgment was that the Hindu Marriage Act does not lie or it is barred.
Yes.
Now the court has said no, it can't be a bar. So
Section 7.
Then you go there.
Section 7 is there. That's what. But deciding on merit, that's what I
that
think
can be. What is the difficult? Under Order 14, Rule
I don't.
Rule 2.
Lord, I don't question
Is
the
it
power.
a duty of the court to decide
Yes.
all the issues? However, it shows that if one of the issues will clinch, he may not. That's the question. He may not.
No, I beg to submit that he should. The matter should have been limited to decide according.
The question of remand is not reviewed.
But it becomes a wrong judgment.
Order 41, Rule 23, 23A, 24. There are when the court can remand. It's not a matter of right.
What I beg to submit that proceeding on the footing that
No.
they have
not coming under the review. No.
That is the only part. That is the only part.
No, sir. It does not come.
That is the only part.
It may come. You can go higher up. There is no difficulty.
Your Lordship distinguishing erroneous judgment and
absolutely. These are the very basic tenet of the
review. I only pointed out that basing on the proceeding
points which were argued and ultimately interpreted by the court, interpretation may be wrong, but it is a erroneous judgment, but cannot go beyond.
On the basis that parties are Hindus.
That is what is apparent from there must be some finding, there must be some evidence, there must be something which
because nothing has been decided. Nothing has been decided.
No, not decision, but
no material.
What the appellate court does, suppose the trial court has not considered a particular piece of evidence which is vital, the court can.
Court can do it.
There is no difficulty. An appellate court exercises all the powers of the trial court as well.
Yes, definitely.
I believe section 105 or 107 of the civil
107 of
CPC. So there is no difficulty.
There I don't question that power, but
no,
that is the only part.
No. That it can. Right. You just send it. That's the very first judgment. Very first judgment.
Whereas myself and oblige.
Obliged.
For judgment. All keep it for judgment.
Item number 4.
Who is
Item 4.
Sir, Mr. Chand said to pass over the matter. I am in person. And the party in person.
yes, you are appearing in person.
Sir, Mr.
You
Chand,
are
I
filed in
request,
person.
I requested Mr. Chand said to pass over the matter.
Yes. 5
Item number 5.
adjourned to be listed on the plate.
Milord, in this matter, I'm praying for a short adjournment. Milord, we'll file an affidavit by tomorrow, Milord.
What for?
Milord, regarding the compliance of the order, Milord. Compliance of the order.
But till date, no complaints or no so-called reply has been filed. Since the
So now he's finding that I have already complied the order. Mr. Tripathi, the learned advocate appearing for the LS container submits that the
Item 6.
It's my lord, I have filed no objection certificate from the earlier council, my lord.
what is the error committed by
Here, my lord,
the division bench?
my main ground, my lord, is the suppression of material facts.
Was it there on record?
It is in the lower court record, but that has not supplied to the workman. And
That was not supplied.
to the workman, that it is under Minimum Wages Act. It has not been supplied to the workman.
Show us the law that suppression of the fact
Is ground of
which is
review.
not which does not germinate from the record is a good ground for review.
My lord, what I suggest, what I submit, my lord, it is in the lower court record. It is in the record before the authority.
Yes.
And while disposing the petition, my lord has pleased to direct the authority to supply the copy of the record. And
Yes.
from that, I found that it was already on the record of before the authority, but has not produced by the opposite parties in the.
So that is the ground for review. That is what that means. Record means record of the proceeding or a record maintained by the administrative department.
I have a decision, my lord, suppression of material facts.
Can it be a ground for review?
Yes.
Sure. Sure, sir.
Madam.
Yes, coded distillers. Yes.
Here also, last paragraph 28, 29. In this case, we find that special petition was dismissed with the following order passed on 5/1/2012. we find no ground to interfere with the impugned order. The special leave petition dismissed. Here also the special leave petition was dismissed in limine and without any speaking order. After the dismissal of the special leave petition, the respondent in this appeal has approached the High Court with review petition. The said review petition is allowed by passing order dated 12/12/2012.
Is this the ratio of the judgment? That can't be. And what was the suppression is the suppression of certain materials which was already there on record. Not the record of the administrative authority, but the record, judicial record.
Before the because my lord,
Judicial record, sir.
yes, my lord, authority
There are two aspects. If
My
the fraud is committed, then it's another ground.
my lord,
There's another ground because the fraud unravels everything.
my lord,
Even in the collateral proceedings, you can raise the plea of fraud. We are conscious.
my
But what about the suppression? It was not there on record. They must have hide it.
no, they have that I am submitting, my lord. They have not filed before the Writ court, my lord.
So what is this? Why? So can it be said to be a ground? You can go higher.
My lord.
You can go higher.
Because if that document was produced, the findings could be otherwise, my lord.
No.
Because that is an error of fact, my lord. And because
Problem is you have to show that it was part of the court record.
yes,
You
my
are
lord.
saying something. You are saying that now have like something was there in the record of the officer of the office, which would have resulted in a different conclusion.
That, my lord,
Here it is a never-ending exercise.
no, my lord.
Tomorrow, you are applying for whom actually? So Bhanti, you are the
Please, Vilas, I was for the petitioner.
you are applying for fine.
No,
No, my lord. I am
He
for the
is
workman
appearing
there.
for the workman.
You are
Who's
applying for the workman.
Mr.
My lord,
SP Jena.
Mr. SB Jena, my lord.
And engage you. You should be present.
Present.
There is a bar by the Supreme Court.
That decision, my lord, last time that's
Because he has to matter by a
that
great counsel. When legal counsel is available,
my lord.
then at least he should not
Because my lord, he has given.
senior counsel of engaging others.
Because my lord, he has
Then
given.
he said that the lordship strictly interprets.
My lord, I understand, my lord. I understand, my lord. Two aspects, my lord. One is, my lord, he has given the consent and he is not interested to appear, my lord. And
Then can that be a method for
And-
circumventing the Supreme Court order?
that Supreme Court order, what
Can
my,
read that.
my lord, last time, my lord, and
Then it is the easiest way to circumvent the Supreme Court order that after arguing the matter, you give consent. I thought you are, Mr. Mohanty was mentioned as the, but since he's maintaining some distance between both, the physical distance. That is how I asked.
my lord, last time, my lord, friend has produced that decision, my lord. That says, my
No,
lord.
there are several decisions
No.
that has been followed subsequently by other high courts. Lordship has followed. So, I mean, it becomes difficult
My lord, no,
and noticeably because that will be again a error apparent on the face of the record that we have heard another lawyer
here, my lord, you
on the specious plea that he has other lawyer has given consent after the matter is closed.
here, my lord, a workman is surviving on minimum wages. And
He also survives the law also.
my lord,
I mean, even if you take a favorable view that you have to follow law.
my respect.
So what is the difficulty in bringing him on board? And re-engaging and re-arguing by the argument by the another
Difficulty, my
counsel.
lord, it is the
He can argue make the same argument what you are arguing.
subject to his willing, my lord. Both the client and advocate.
How can we adjudicate who is willing, which lawyer is willing or not
That
willing?
cannot be argued.
Please appreciate that.
That's why
It's a very difficult proposition you are.
that's why he has. That's why he has given the consent, my lord. And technical objections, my lord, when substantial justice is there, my lord, I.
Copy of the judgment.
That is there, my lord. It's
Purely, your coded distillers is different. You are, this is purely an obiter dicta. This is not a law letter. It was unwarranted. You're taking. Any other judgment you have?
my lord, give me some more time, my lord.
What more?
Let me analysis.
Courted distillers was considering a case where the special petition got dismissed and whether the review application is maintainable before the High Court.
That is the main issue.
And that's a Humayun judgment of 2000 was also taken into consideration.
That is the main issue in that case,
And
my
that
lord.
was there, and it says that there is no bar in maintaining the review application after the dismissal of the.
My lord, what my lord is suggesting that is correct.
In limine, that's true. That's a limine without any observations.
My lord,
Just for the record.
The doctrine of merger was considered to be a paramount consideration.
that is there.
And there it was not warranted. Some line is given. It's not warranted. This is arbiter dicta.
Malad,
Finding
Give me some more time.
was not Article 141, sir.
Give me some more time, my lord. I will.
How many times you will ask for a adjournment?
No, my lord.
You have given it. We will decide on that basis on this judgment. We'll decide.
Give me some more time.
No.
Just one more time, my lord.
What more time, sir? Unnecessarily, you are keeping this matter pending.
No, my lord. I will place my lord. Some.
No, sir. This is not expected.
My lord, one more time.
Just for the record, Malad, there is an IA for delay methods where the only ground taken is that the previous counsel, when the petitioner approached the previous counsel, apparently he did not respond. That is the only Malad's reason.
No, that is not the ground.
Malad's may
My-
be Malad's. Malad's may see the
No,
delay.
ask you. You just give it.
See the
give
delay.
to me. No further adjournment.
Please, Malad.
Hearing, we have
Just 1 minute.
Courted distillers will consider that judgment you have cited. Decide.
Item 1, my lord. I'm paying a short adjustment because Mr. Lawrence Senior Advocate Mr. Mahapatra is felt ill, my lord, so he has to leave, my lord. My lord, next week only any date, my lord. Limited.
Accommodation sought for on the ground of the senior advocate who is in this post.
My lord, may I pray for it because this
It
20th.
will be given. It will be given.
20th.
Give it after 3 weeks.
Item number 2.
My lord, the registry has suggested for taking out notice again.
What is this SAO? How it is registered as an SAO?
My lord, it is a appeal against the order passed by the London District Judge refusing to rehear the miscellaneous appeal against the FAO.
Whether the appeal is maintainable?
Yes, my lord.
How? Miscellaneous appeal is under section 104 of the Code of Procedure. Is it? If it is 104 of the Civil Procedure, it says that no further appeal lies. If no further appeal lies, then rehearing under Order 41, Rule 19 or is not a appellable order. If the principle is, if the relief against the final order is not an appeal, then whether against the interlocutory order, the appeal
That's
will be
right,
there.
Lordship.
No.
Apparently.
No.
Right. Your Lordship is right, probably.
No, then you'll have to go for revision.
I'll examine it, Your Lordship. May call
I'm
it on
giving you
20th.
a noted judgment of Sir Asutosh Mukherjee
Yes,
of
my lord.
that time era.
I'll see, my lord. Your Lordship may
It
call
says it cannot be done.
Call it on 20th. In the
sir.
meantime, we'll.
It's a revisional application. I was wondering that how SAO lies.
My lord, that
Even an injunction application is filed in an appeal. If the injunction is refused or granted, though under Order 43 Rule 1R, it is an appeal lies, but it does not lie because of the embargo under
My
section
lord.
104.
I'm conscious of it, my lord. Your lordship is right. But now I have to file an application for converting it.
Not application, the court can suo
My lord,
motu
that's true, my lord. That
So,
for
the
that
court can
purpose,
suo motu-
that purpose only I was saying that if your
Yeah,
lordship,
1980 Supreme Court.
yes, that
The court can convert.
court can convert, but as for my lord, I will say that we will file an application and do that.
No.
If your lordship will direct, then it can be done.
Just give it to me so that I will record the reasoned order citing 2-3 judgments so that in future there will not be any SAO. You just send it the file to my. Come.
I pray
Just
for
remind me.
conversion, my lord.
I will do it.
Oblige.
Don't worry. It's the High Court 227
Yes,
there.
I
But you'll have to pay the differential court fee.
yes, my lord.
I do not know. What is the same court fee or a differential?
My lord, little bit different. 10 rupees or 12 rupees will be there.
More.
Now, yes. 32 rupees.
That troubles me when it was coming. I said, how a SAO lies.
That's right.
Item number 3.
3 here, my lord. I have the instruction, my lord, to appear, my lord. But I hope that if your lordship will take it on 20th, I will file a brief note indicating the substantial questions of law that it needs to be formulated in a clear manner. For that, your lordship will kindly call it on 20th.
There's a mandate of the RERA Act.
Under section 58, my lord, it will be a second appeal like section 100.
Section 100, I know.
Yes.
The substantial question of law has to be framed.
Framed by the court, my lord. I will assist, my lord, in
True.
giving the points.
Can you show me the law?
My lord, section 58, my lord. Appeal to High Court. Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the High Court within a period of 60 days from the date of communication of the decision or order of the appellate tribunal to him on any one or more of the grounds specified in section 100 of the Code of Civil Procedure 1908.
The substantial question of law.
Yes, my lord.
To come distinction between a question of law
and substantial question of law. Every question of law will need not be called a substantial question of law.
The Supreme Court.
Yes, my lord.
Consider.
Must
you want?
Kindly call it on 20th. I'll come.
20th. No, 2 weeks.
Because, my lord, unless it is taken up early also, because further coercive action they may take under section 59. That is why I pray that your lords may kindly take it up on 20th.
20th will be arbitration preference. Consider it on after 2 weeks.
Item number 4.
Same thing is SAO.
No.
Yeah. Second appeal.
Appellate order of remand is challenged. Under order 43 rule 1.
Is it appellate? It's a order of remand.
Remand by the first appeal. And that
will
is
it not be considered as a miscellaneous appeal?
That was previously numbered as miscellaneous appeal because your lordships amended the.
Because under order 43 rule 1U.
Right, Miller. You it is appellable. And previously all.
But it's the miscellaneous appeal.
Previously it was numbered as miscellaneous appeal. Now because of the changes in the rules, Miller, High Court rules, Miller.
Then show me.
But the rules I have not.
Give it to
Miller. They were nomenclated it as.
I am not aware because
Miller, please.
In another high court, these appeals are registered as MAT.
Miller.
First miscellaneous appeal tender number.
Lord, your lordship may pass over in the meantime.
Yes. Find out the relevant provision.
Miller.
Item number 5.
Where is the impugned order?
Yes. Look, here, in fact, the learned first appellate court
This is the order in FAO.
Yes, ma'am. Order in FAO.
What is the order?
Yes, ma'am. It has been remanded, page 92, annexure 9.
Just annexure?
Annexure 9, my lord, page 92.
Just 1 minute.
My lord.
Sir, I could not make a head and tail from the judgment. What
Well,
is the? Is a suit for partition?
It's a suit for partition, my lords.
It has not reached to a preliminary degree stage.
It has not. So at this,
An injunction application is filed in the suit.
yes, ma'am.
That was allowed or
Allowed.
refused?
Allowed means.
Allowed. Order 39 rule 1 and 2 were disposed of or
Disposed of.
interim order?
Disposed of. Means. It was the order was made
temporary
absolute.
injunction was granted.
Yes, ma'am.
Challenge is made to the first appellate court.
Yes,
FAO.
yes.
Then what happened? FAO has remitted back.
But its FAO was allowed.
initially the FAO was allowed, confirming the
Setting
order.
aside the order.
Confirming the order.
That not allowed. Then
I'm sorry, it's dismissed. I'm sorry. Beg your pardon.
Yes.
Confirming
And
judgment.
the CMP
was filed. CMP at the stage of admission, my lord, the matter was remanded on the basis of two documents, which was filed for the first time in the CMP. The first appellate court, after the order of remand by this honorable court, further remanded the matter to the learned trial court, which is the subject matter of challenge before your lordship. Because the humble submission of the petitioner is that it could have been adjudicated by the learned first appellate court on the basis of the two documents, on the sole question as to
what
who
are
is
these two documents?
Because these two documents is one is, may I just give a brief background of the
Just tell me what
file.
are these two documents?
So these two documents, one is an ROR, a record of right,
yeah?
which has been corrected in the name of the defendant. The other is an unregistered partition deed, which he relies upon to say that there has been a previous partition, thereby negativing the need for a partition in this particular suit. So these are the two documents.
Now, what was the nature of the injunction?
The nature of the injunction was status quo, my lords.
Status quo is a vague.
So
I am asking what status?
Status quo with respect to possession.
Or what?
Possession, my lords.
Alienation, possession, what?
Possession, not to alienate, not to change the nature and character. That was the nature of the status quo. Now, my lords, this suit for partition is filed. These are co-sharers, my lord.
Partition means that.
Well, so one of the plaintiff says that these properties have not been partitioned before and he is entitled to a share. The defendant says that some lots of the properties included in the suit for partition that has come to him by way of a will, which has been probated.
Was that property an exclusive property of the testator or testatrix?
That is what the claim of the defendant is, and which the plaintiff says that no.
That testator or testatrix was the co-sharer of the.
Yes, he was one of the co-sharers. Yes, he was. The plaintiff says that he was a co-sharer. The origin of the property, he says, is an ancestral.
What is the defendant's view?
The defendant's says that it's an exclusive property, a self-acquired property of the testator.
Okay.
Well, that is the rival contention. So both the learned courts below and the first instance below, they allowed my application saying that the property needs to be preserved on the basis that the will may have been probated, thereby rendering the will to be a valid document. But whether the testator had right title interest over the property or not, that is to be gone into at the time of trial. Now, these two documents were filed for the first time in the CMP before this honorable court.
What is the date of the order? What has happened after that?
Well, it's this honorable court has.
IA has already been disposed of.
No, it's pending by virtue of an interim order passed by this honorable court.
Interim order is passed.
Yes, my lord.
Interim order of stay of the.
Yes, well, the operation of the order was stayed. But your lordship will kindly peruse order dated 14/7/2025. Order by Honorable Justice B.P. Rautre, IA number 1003 of 2025 on that very same day. Well, the operation of the impugn order was stayed.
Anyhow, I do not want to make comment. You are a plaintiff.
I'm a plaintiff. I'm the plaintiff.
You are claiming possession?
But I'm claiming it's in joint possession of.
That's true.
Well,
I am conscious of the concept of the co-pastory properties or the.
I'm obliged. I'm obliged. The only document which the defendant relies upon to show that he's in possession is that record of right which has been corrected pursuant to the probate granted in the will. That is the only document which was in fact not filed before the learned courts below.
But anyhow, the High Court in CMP permitted it.
Mine.
So where is the difficulty? Why you do not want to fight it out?
The Your Lordship will kindly see.
We can fix
I'm
a
ready.
date.
We
can fix a date within which the IA application has to be disposed of.
I have no difficulty in fighting out.
Why you want to lose one forum?
I in fact have no difficulty in fighting out. But what my humble submission is
Is a healthier remand, let him go and will say that within a time frame.
Your Lordship will see the scope of remand by the learned first appellate court. That is what I'm aggrieved.
Rehearing of the
Rehearing by way of taking oral evidence, my lords. So the concept
not necessary.
That is what he has written. That is what I'm aggrieved with, my lords. Your Lordship will kindly see. That is page 112 of the brief, the ordering portion of the judgment passed. Plus, that is enlarging the scope of remand by this honorable court.
Who is for the other side?
Ma'am, there for the other side.
Sir, only thing is how I'm really in fix. How the injunction applications are decided on a oral evidence?
No, my lord, it has to be both on.
Under Order 19, it has to be decided on the basis of the affidavits.
Ma'am, I'm conscious of that, madam. I'm not disputing.
So
What
we
has
are
happened?
we are simply modifying the order that no oral evidence is needed. Whatever is the document which is there, they have to decide on that basis.
Ma'am, may I just clarify one thing? My learned friend has not possibly read the remand order correctly in the sense you would not have pressed this, but he has said oral documentary evidence
So
to
it's
dispute.
required. I have gone it, sir.
Madam.
When any observation is made, you are there. I was also there for a pretty long time. How it is interpreted?
It
By
was in
your counterpart there.
It was in their favor
Oh.
to dispute annexes 6 and 7. My lord, may kindly see.
Not dispute by injunction applications are decided on a prima facie basis.
Absolutely.
And the law is that no observation can be made by a judge which will be really non-suit any of the parties.
He has not done that, madam.
The question is that's why the oral evidence. I'm just simply to modify the order. We simply say that the application has been remitted for a reconsideration on the basis of those documents which are already taken on record. No oral evidence is warranted. The court will decide on the basis of the pleadings of the parties within a certain time.
One more thing I beg to just clarify. Your lordship was pleased to pose a very pertinent question whether this will was based on his exclusive property or not.
That is what
May I
is the
just
prima
clarify? May I
facie.
just with your lordship's permission? This was a self-prepared property on the basis of a purchase of the year 1959. Post facto that, in consultation proceeding, which is a title adjudicating authority, my recording was made in favor of the person who has executed the will, and only after he has executed the will.
We are not entering into that merit
My-
of the case. That's why I was avoiding it.
My-
The merit of the case, then once he has brought those into the hotspots,
He has
then
not.
in that event, it is in that event you can claim the exclusion of the properties in a partition suit. That this property does not belong to a co-pastor. It is an exclusive property of the vendor, and therefore the plaintiff does not acquire any title by way of inheritance or by any other means. That is what is to be decided in a partition suit at the time of preliminary degree.
May I just point out one more
Go there.
one more
Why
relevant
oral
thing?
evidence? It will delay the entire process.
A suit was filed by the testator during his lifetime in respect of the other property, not the will property. Now there, a counterclaim was filed by this petitioner saying that the will property should be included. That was not also pressed.
That is, you did not press it.
They did not press it. So therefore, this is also barred by res judicata, your lordship, so far as the claim, so far as the. But there was a counterclaim. There was a counterclaim, your lordship.
No.
My lord.
I know, but one has to understand. There are many facets to bring that question of res judicata under section 11.
True, it is, my lord.
So we can't decide it at this stage. Only thing is oral evidence I have never heard of. Injunctions are decided on the oral evidence.
It can be on affidavits, my lord.
Yes.
There is no dispute
That is
about
what
that.
we wanted to say within a time frame.
And it was in fact in their favor, but he wants it should go.
Right.
Because if your lordship sees the order, it was for their favor.
The application under Article 227 of the Constitution of India is taken out against the
But it's that oral evidence your lordship has expunged.
I have already said on the basis of the affidavits and the documents, not
Yes.
itself.
Yes.
It's
Obliged. I prefer.
Take the line where I have said affidavits and not documents and not the oral evidence. Just
gratefully.
Yes.
Arbitration matters, test admission item number 6.
Item number 6, my lord, I'm appearing on VC for the petitioner.
Where is the arbitration clause?
My lord, at the outset, my lord, I just humbly request for an adjournment in this particular matter because there is a possibility of a out of court settlement in this particular matter. That's the humble reason I've just requested.
Submitted by the counsel for the petitioner that there is every possibility of a
Item number 7, my lord, I'm through VC, my lord. May I be permitted?
Where is the arbitration clause?
Yes, my lord. Arbitration clause, in fact, the entire agreement has been given by a separate affidavit that said flag A, your lordship. Kindly see there, the agreement is there. Flag A.
Yes. Show me a arbitration clause.
Yes, my lord. My lord, may kindly turn to page 45.
Page
45.
45.
Okay. Yes, my lord. Towards the bottom, 64. Demand for arbitration. Lordship would kindly turn to the next page, 64.
Where is
The entire procedure for appointment of arbitration.
120 days. First thing is that show me the letter and then the 120 days.
Yes, my lord. My lord, may kindly turn to my petition, page 74. My arbitration petition, page 74. Annexure 11, my lord.
No, it is not an arbitration matter.
There I have first issued this letter to the general manager claiming my lord, raising the claims. In spite of receipt, the general manager has not intimated any decision. Thereafter, my lord,
This is a section 21 notice.
my lord, this is pre-section 21 notice as per the arbitration clause, my lord.
I really wanted. So it's a pre-21.
Yes, my lord. Then
So
21.
that is a letter dated. Which one is
30th October 2024, my lord.
120 days.
Yes, my lord. So in spite of expiry of 120. Pardon me.
What is this? Page 91.
Page 91 is a 21 notice, your lordship. After 120 days.
Before 120 days. How can you give it within 120 days? Because the clause says that you have to wait for 120 days. If they do not, then you can refer the matter to arbitration.
Yes, lordship.
You are appearing?
Yes, sir.
Railways?
Railways.
What are you doing?
We didn't have a copy.
Give him a copy. Service. 3 weeks. Next.
Item number 8.
My lord, item number 8, I appear for the my lord petitioner. This is a section 11 application. Page, my lord, 820. Page 100 and 820, my lord, clause 20.6. Page 820, my lord, clause 20.6.
820. There is a second volume.
Yes, my lord. At clause 20.6, lordship will find the arbitration clause.
Give me. Yes.
My lord, this is 20.6 at page 820, the last clause. Any dispute between the parties arising out of the connection with the contract, not 820, my lord, last clause, 20.
My system is not saying. Just 1 minute.
Very well. I'm sorry, my lord. I was.
Yes.
Yes. 20.6 page 8.
20.5.
20.5 was, my lord, adhered to. No party has a dispute to it. 20.6, my lord, is the arbitration clause. Accordingly, we gave a 21 notice, my lord.
Where is a 20.5 notice?
My lord, that is not disputed. I'll show it from the 21 notice reply only. That is not in dispute, my lord. My lord, the 21 notice of
Show us that where a notice of dissatisfaction has been given under clause 20.4, then there is a modalities which is given. Show us that you have given a notice.
my lord, there is no notice as such between the parties under 20.5, but it is not in dispute that, my lord, the parties mutually, my lord, sat and it did not work out, my lord. That is, my lord, there only, my lord, dispute with regard to the arbitration is that they want somebody, my lord, not the name of the honorable justice that we had. My lord, I have served on the other side. There.
Served with the copy, Your Lordship. We are filing the Wakalatnama today.
You served with the copy?
Yes, Your
Yes, long back, my lord.
I can file your opposition.
Your Lordship, may allow me some time to obtain instructions, Your Lordship.
My Lord,
Are you going to file an opposition?
No,
I mean, the counter affidavit or what?
Your Lordship, for that I'll require some instructions, Your Lordship.
Instruction?
Because, Your Lordship, there is some amicable settlement talks which are.
My lord, only there is no amicable settlement, my lord. The only
That is the reason, Your Lordship.
they have is with the name of the honorable justice. I am agreeable to lordship's appointment.
Where
Want, my lord, the arbitration to take place in Delhi. So,
my Lord, I am for the petitioner
my lord,
along.
kindly sees the reply.
My Lord, may see page 1795 and 1796.
My lord, kindly sees the reply.
To our section 21. They have agreed that
they have agreed, my lord.
There was
only dispute was with regard to, my lord, the
regarding the
name
name of the arbitrator. 1795 and 1796.
We had proposed Justice Pranab Chattopadhyay, my lord. They have disagreed to. We are agreeable to any, my lord, retired. One 179.
Just 1 minute. I am just going
Clause
through
2.
the letter.
Very, very well, ma'am. I'm sorry.
So they have not agreed.
Yes, my lord. We gave a reply to this also, my lord.
High Court has to appoint.
My lord.
Yes, my lord. My lord, only request we have, my lord, since the parties have a dispute, if it is a retired Supreme Court judge, my lord, we were proposing Justice Ashok Ganguly. If my lord, they have a problem, then lordship will appoint somebody else.
No, we will appoint independent.
May I pray, Your Lordship? Lordship, in fact, after this, there are some developments, Your Lordship. The parties had sat together for a settlement, Your Lordship, and I have been informed.
My lord, I have taken instructions. This is not true.
And they wanted to give further instruction, and that is why I am pleading for some time, Your Lordship. That is
My lord, I have taken instructions. There is no settlement, my lord, as far as our end is concerned. There is no settlement, my lord. Lordship will appoint it.
That is what is my instruction, Your Lordship. That in fact,
When you take the instruction.
Today in the morning.
Huh?
Today in the morning, Your Lordship.
Today in the morning.
Yes, they told me, Your Lordship. In
Yes,
fact,
we are fixing this matter in the next way. Yes. The There's
Your
nothing.
Lordship, in fact, they're sitting on the 25th. That is what my instruction is.
Anyhow.
Today also I've taken instructions. There is nothing of this
That's
sort.
what I said, Your Lordship. Any date after 25th.
On 27th, my lord. 27th.
Huh?
On 10th.
27th is a holiday. 27th is a
My
holiday.
lord.
So it has to go on a
10th April.
no prior there too.
3rd April also.
3rd April is also a holiday.
Yes, prior that one.
10th April, Your
10th.
Lordship.
10th.
Item 9.
Obligation.
Great.
My lord, item 9, may I please your lordship, my lord? My lord, this is
Where is the arbitration clause?
my lord, arbitration clause is at page number 39, my lord.
39.
Yes, my lord. Read with page number 156.
Just
Yes. Last paragraph.
yes.
Clause 6.
Where is the clause 87?
Clause 87 is as page number 156. 156, no.
Yes. Where is your section 21 notice?
My lord, section 21 notice is page number 189. Oh, sorry, my lord, 190.
What?
190. 189 is the email communication, 190 is the 21 notice.
Where is the document showing the receipt is sent?
My lord, we have sent it by mail at the page number 189, and the receipt is at page number 195.
They have not responded.
They have not responded, my lord.
Service 3 weeks.
Public.
Item number 10.
Where is the arbitration clause, sir?
Page 12.
Yes.
13.
Page
12.
12.
Clause 13. In fact, I had given a
Just
notice.
a minute.
All the parties to the dispute related to partnership business shall decide.
No, I'm not. 15.
1-3. Page 12.
Yes.
Was 13.
Yes. Where is the section 21 notice?
That's at page 15. In fact, I had suggested the name of a retired judge.
Yeah.
I had suggested the name of a retired judge, but he refused.
Oh, that's true.
And he has refused. I'm sorry, I'm so sorry that the posted endorsement refusal.
So where is their refusal? Why don't you include it, sir? It's a part of the record.
By oversight, by mistake, I couldn't find it.
It's not there. We can't take it in this way.
No,
You
no.
have to file it by way of an
By
affidavit.
way of a memo, I'm filing it. It's
Anyhow,
taken on
not
record.
a memo, sir. It does not becomes a part of the record. It must be an annexure duly verified by you.
I have verified. I have verified. I have given the
Service
tracking report.
3 weeks. Sir,
I have given the verified tracking report. By
affidavit.
mistake, my clerk.
Affidavit should be there. Not a memo.
Passed over that.
Which one?
So,
Yes, have you got?
Yes.
Which one?
There are the notification. 2002.
yes, sir. What's your
Page number 588. 588. Lord's Mercy 3B. Appeal from appellate order, SAO.
when the second appeal lies.
Milord,
Sir, there are many where the second appeal, it does not talk about it is appeal from an appellate order. What does it mean? Suppose there are certain adjudications where the first appellate court has entertained.
Right.
Then in that event, it will be deemed to have been filed. They say, for example, the deemed degrees. Say Order 21, Rule 101 of the Code of Procedure.
That is also a degree.
It's a deemed degree by virtue of Rule 103. It's a deemed degree, not it's an order.
An order with a force of a decree.
Having a force. So there the SAO can be filed because it is an appeal before the first appellate court.
Your Lordship will further clarify chapter.
Because I just wanted to know where this second appeal would lie from an appellate order or further appeal.
Your Lordship, here the further appeal is provided under the code. Order 43.
That is what because of the problem. 104 is the problem. There are civil procedure code is divided into two parts.
Absolutely.
One is a substantive
part,
another is a procedural.
Right.
Substantive is 104.
Right.
Order 43 is the procedural.
Right.
104 creates an embargo. No further appeal lies from that order.
Unless there is provided under.
No. There is a bar. Give me section 104. Look at subsection 2 of 104. Hey, sir, give it to just give it. Give it.
Miller.
Subsection 2
Miller.
Reads that 104 is the right to appeal before the first court.
Right.
Subsection 2
Miller. No appeal shall lie from any order passed in appeal under this section. Miller.
So that shows that the appellate court, if it passes an order, then no appeal lies against that order.
This 104 Miller is regulated also because of order 43.
No, sir. 104 is a substantive provision.
Absolutely correct.
And the order 43 is a
procedural
aspect.
Right.
So if 104 will have an edge over the order 43. Now there are two things. If you look at the provisions, sections are a body of the code.
Right.
And the schedules which contains the different orders and the rules are the procedural aspect.
Right.
If there is some kind of a discrepancies between the procedural provision and this body of the code, it's the body of the code which is paramount.
It will prevail.
Because I have delivered a judgment, that is what that troubles. That even in an appeal section 104, an injunction is filed. Injunction is disposed of. Then what is the remedy? Because under order 43, rule 1R says appellable order.
Appellable.
Then by virtue of this subsection 2I says no. It's a revisable. It will not be an appellable.
I have examined that your Lordship's judgment in
Please consider. I have taken these views right from that old concept of the Privy Councils. The concept is that when remedy against the final order is not an appeal, then against an interlocutory order there cannot be an appeal.
That is one aspect, Millard. Here the body.
That is the primary aspect.
Millard, that's correct, Millard. But that may not be applicable here, Millard, because here the appellate order is appellable under section 100, Millard. The appellate order otherwise is appellable under section.
under section 100. No, that is the second appeal. Right, Miller. So no difficulty. Miller, then why? Oh, Miller, the difference is Miller. Acha, interlocutory. Interlocutory. It is not. I understood. Miller. Still, it will not. Miller. It will not because of 104 subclause 2, Miller. I will clarify this question since your lordship cannot. Miller, there has been held. Your lordship. Yes, there is two judgments. Miller, your lordship, kindly since your lordship is making a query about the your lordship's rules, Miller. Lordship's. No, I know there are certain orders which are appellable, Miller, which can be said to be a second appeal, Miller, order, Miller, SAO. Miller. In Calcutta, we call it a second miscellaneous appeal. Miller. SME, not SAO. Miller, here chapter 12, Miller, your lordship, see page 91. What? Odisha High Court rules. Miller. What it says? Miller, I'm placing it. In second appeals from orders, including the orders under section 47 of Code of CPC. 47 is not an appellable order. Thereafter, Miller, it says value below 1 lakh and in appeals from remand orders under order 41 rule 23 of the same court. Correct. That categorization I am really surprised because there it is always regarded as a first miscellaneous appeal. Miller. I can understand. Miller. I can understand the SEO can be maintained against the order of remand. Miller. But the difficulty is the categorization is very. Miller, if your lordship see chapter. This is the order of remand. Yes, order of remand. Come on the next day. I will consider it. Miller. May I pray? In the next sitting, your lordship, since your lordship has raised a query, Miller, I'll try to meet it. Come. Yes.